This conference will now be recorded.
Hi, good morning, everyone. Welcome to the Catholic Estate and Personal Planning Seminar. My name is Maureen Lindgren, and I'm the Executive Director of the Foundation of the Diocese of Raleigh. Welcome all of you for coming today. We at the Foundation do a number of things, but one of the resources that we provide to all the members of the diocese is the Plan Giving and Catholic Medical Directives information. What we do is we'll have Ryan Flood and Charlie share with you information both from a financial perspective and a legal perspective as you start to plan and think about creating a will, making medical directives. So thank you for joining us. So I want to share a little bit with you today about the Foundation of the Diocese of Raleigh. We were created in 2018 by Bishop Zarama, and our role is really to work with parishes, donors, and the diocese to plan for the long-term health of our diocese, specifically in the areas of endowments, in bequests, in raising money for initiatives such as the Seminarian Partnership Program, the Land Trust, and Home Mission. So currently, we cover all 54 counties of the diocese. We manage all the endowments here, and what I mean by manage is we administer them. We have a team of financial experts in our investment committee that actually do the financial management of the endowments. All of our endowments meet the Catholic Conference of Bishops guidelines. So again, we continue to grow endowments here. Our endowments support parishes, they support ministries, and they support some of the general operations of the diocese. We report into a board of directors made up of successful North Carolina business leaders and civic leaders. The chairperson of our board of directors is Tim Mann. Many of you may be familiar with Tim. And again, we have over 150 parish, school, and ministry endowment funds. Next slide. So I'm going to hand it off to Ryan Flood. But before I do that, I do want to apologize. I do have to leave our call. I've been asked to join the Raleigh Deanery meeting. So again, we interact very much with the clergy as they make plans for their parishes and their deaneries. But before I do so, I would like to invite you and encourage you to please visit our website, foundationdor.org, and I'm sure Lisa will share that information with you, because then you'll get a real feeling and understanding of the foundation and all the good works that we do here. So thank you for joining us today, and I hope you have a very productive session. And I'll turn it over to Ryan.
Thank you, Maureen. As Maureen said, my name is Ryan Flood. I'm the Director of Special Gifts for the Foundation. As Maureen said, we cover a number of areas, both in outright giving and plan giving. Today, I'll talk about some of the ways that people prepare for their estate planning. We'll talk about some of the popular ways that people give. And then we'll turn it over to Charlie Davis, who's an attorney in Raleigh, and he'll talk about the specifics of the documents that every estate plan needs. And then we'll wrap it up with a summary. Hopefully, we'll be done in about an hour. And I just want to make a point here. Tomorrow, if you live in the Raleigh area, we're giving the same seminar live at St. Luke Catholic Church in Raleigh. It allows for a little more interactive session. We're limited here with the virtual session, but if you live in the area and you would like to attend another free seminar, that's tomorrow at 10:30 at St. Luke Catholic Church in Raleigh. So without further ado, we'll begin. So I've had about 22 years in this line of work, and I've worked with a number of people on many different plans. And today I'm just going to share some of my experience with you. When people begin planning, it's the largest asset transfer that one will ever make, most likely, right? So we want to put some time and effort and thought into that transfer. and it's going to have an impact. And we want to do that with the utmost care. So we want to bring it to prayer first and foremost. And we want to ask ourselves, what mattered most to us in our lives, right? Of course, our family, our church, our friends, our community. Well, what mattered most? What did we put our blood, sweat, and tears into, so to speak, while we were here on this earth? And how do we want to continue that legacy to future generations? How do you want to be remembered? Some people would like to be remembered with a named endowment, right? And some people want to be totally anonymous, and that's fine too. We can accommodate that as well. We want to pass on our values more than our valuables, right? It's important that the lives that we have led will hopefully inspire others. So, what is it in our plan that we can do to pass on those values? And how do you get from here to there? And that's what we're going to discuss today. So a few initial questions. The big overarching question there is, what am I trying to accomplish? And the three questions there is, how much will I or my spouse and I need to live on for the rest of our lives? That's typically answered by a financial planner. So if you have a financial professional that you're working with, that's a very key question that you want to work on, and coming up with an answer for that. How much would you like to leave to children, grandchildren, and in what form? Right? I mean, some people will leave an outright gift. Some people will set up annuities or trusts, which will leave streams of income, maybe for life or for a term of years. We'll talk about that. And then what, if any, do I want to leave to charity? And these are some of the points we'll talk about today. One of the ways that we've helped people over the years with planning, we've given away hundreds of these, is the Catholic Estate and Personal Planning Workbook. If you would like a copy of the workbook, please email us and let us know, or give us a call and we'll get you out a copy. This workbook has been very helpful to a number of people over the years. It was created by a former colleague of mine who had a situation with his aunt where she had some assets, but she passed away intestate, which means she didn't have a plan or any plan. And so it was through that challenging process where he put together this book with with an attorney friend of his. And it's not a legal document, but what it does is it helps people prepare for a meeting with an attorney. And it has everything there, from listing your assets, liabilities, down to what a person may do after the first month, first year if someone's passing, has grieving resources, and a whole bunch of different things in there. So if you would like a copy, please let us know and we can get you one. The neat thing there with the workbook is that it serves also while you're living for people who will be looking after you or may look after you. Lists of different things like who your doctor's is, insurance agent, financial advisor, has all information for there. So it is somewhat confidential, but you don't want to put it in a bank lockbox or anything like that where nobody can get to it, or very few. You want to put it in a secure place, somewhere in your house only a few people know about. And it's helped a lot of people over the years. Some of the benefits of plan giving. The mutual benefits between you, your parish, and your favorite charities might come in the form of a gift annuity, right? Where you'll receive income for your life, and then the remainder, whatever's left, goes to your favorite charity. You can also set up gifts through wills and trusts, where you don't, you keep the asset for your entire life and it only passes upon your passing. And plan giving, again, helps you make charitable gifts. There's a lot of people out there that want to do something but might not know how, and we're here to assist in that role. Next slide, please. We'll cover these in a little more detail, but again, we have life. The big three categories are life income gifts, gifts from the estate, and charitable funds. Maureen touched on the endowment funds there briefly, and we'll talk about all these throughout the presentation. Some of the popular ways that people have given over the years is listed here. And by far and away, one of the most popular ways nowadays is the IRA charitable rollover. This is for individuals who are 70 and a half and older who want to make a direct gift from their IRA. Now, the QCD is the qualified charitable distribution. This law was written in 2017, made permanent in 2017, I should say. But in 2020, the required minimum distribution age was raised to 72. So even though someone who is at 70 and a half can make a qualified charitable distribution, most people wait until they're 72 and they have to take that RMD. And they don't need that full RMD. They can give that directly to charity. And people don't know that, but you certainly could. And what that does is that keeps your taxable income lower. Sometimes people get a big surprise when their RMD might even push them into a higher tax bracket. And mess up other things there. So it's important to know that you have an option there of giving a qualified charitable distribution. All are part of that RMD, all the way up until $100,000 or anything in between. Typically towards the end of the year, we'll get phone calls of people who want to do their parish offertory for the next year, and they'll use their qualified charitable distribution to do that. Another way people use qualified charitable distributions are for the funding of endowment gifts, or as Maureen said, to support the Seminarian Partnership Program. So there's a lot of ways to use the qualified charitable distribution from your IRA. Now, if you do this, we can do it through the foundation, or you can give it directly to your parish. But please note that there is a special tax letter that you receive, because you don't technically get a charitable deduction for this type of gift. You just don't count the gift as income, as part of your taxable income. So the acknowledgement letter that you will need for your taxes is a little different than the typically one you'll get from your parish, or from if you make an outright gift, from a checking account or something like that. So please note, again, that you have the correct acknowledgement letter for tax purposes at the end of the year if you choose to make this type of gift. And then how to make it. The majority of gifts of the qualified charitable distribution are made from traditional IRAs or inherited IRAs. There's some other options there, but a little more technical, and I would recommend speaking with your CPA if you have any of the other plans. But the majority of the people have a traditional IRA, and that's where they choose to give. We have what is called the letter of instruction for a qualified charitable distribution. You would call the foundation or email us, and we will get you that letter. That letter includes our legal title, tax identification number, address, and contact person of where to send your QCD. And the other good thing about the QCD is you might say, well, I don't want to have multiple qualified charitable distribution checks. Can I just send one to the foundation, and then you could distribute it to, for instance, say your parish, or the Seminarian Partnership, or add to an endowment? Yes, we can do that. So just let us know with a letter or a phone call how you would like us to distribute qualified charitable distribution, and we can do that. And again, the letter is at the foundation, and just let us know and we'll get you that letter. Again, pretty much the same slide there. Sticking with IRAs. Now, IRAs are considered IRD asset. That's income in respect of a decedent. That means someone's going to pay income tax on that IRA distribution, right? If it's you or someone you leave it to who's not a charity. So if you leave it to a non-charity, a friend, family member, whatever amount that is, and how they, those funds come out all at once or over time, they're going to pay income tax on that. However, a charity does not pay income tax on any gift left to them through a beneficiary designation. So you might say, I leave 10% or 25% or so of my IRA to to the foundation for the benefit of, St. Mark Catholic Church, right? Or I leave 25% of my IRA for the benefit of the Seminarian Partnership Program. So you could put that information in there, and whatever amount that is, the full amount goes to fund the charity. As where if you leave it to a non-charitable entity, that person will be paying income tax on that amount. The another thing to keep in mind too is that the when the gift is, the person has up unto 10 years, is a ruling that came out recently, to use their IRA, if they inherit it. So that's another issue. One of the better ways maybe to leave assets to family members and friends or non-charities is assets that get what is called a step up in basis. Those are such things as real property and possibly a stock portfolio and things like that, because those get a step up in basis where they receive the date of death basis, not the original cost basis. So those assets are better left to non-charities, as assets such as IRAs, U.S. savings bonds, some commercial annuities are better left to charity to get the full effect of the amount given to both. Sticking along the idea with the bequests, if you're going to update your estate plan, or if you are making an estate plan for the first time, it doesn't cost anything extra to add a few charities to your plan. Most people include 5 or so charities in their plan, but you would need from the institution, you would need the legal title and tax ID and any suggested wording that the charity may want, and you give that to your attorney. Please contact the foundation for our information, and most people will set up a gift even for their parish. It'll be for the benefit of. So make sure that writing is in there. If you wish to leave a gift, you can again leave it to an outright fund at the foundation. You can leave it to Catholic Charities, whatever your favorite charities there, your parish. But the wording will have to say for the benefit of that particular organization. So just keep that in mind. Life insurance, again, another way that people can give. People have life insurance that they might not need anymore or use anymore, and that's a wonderful way to make a gift. If a parish might be having a capital campaign, I know there was a number of insurance gifts I worked on when we had the cathedral campaign. So just keep that in mind. You can give it all, make the charity the owner and beneficiary, and then you have the ability of a charitable deduction, or you can just make the organization the beneficiary of the life insurance, and then when you pass away, that life insurance will go to the charity, and be used for the intention that you wish. Appreciated securities, again, another wonderful way to make a gift. The market's been quite volatile recently. However, just keep that in mind. If you do have appreciated securities, it's a wonderful way to make a gift. And the key thing to remember too is that there's no capital gains tax when the stocks are transferred directly to the charity. There's no capital gain tax, as opposed if you were to cash them out. Of course, you would be, if there are capital gain, you'd be subject to capital gains tax. So just keep that in mind. Similar to the instructions on the qualified charitable distribution, we have all the instructions that you'll need for a gift of appreciated securities. Just let us know. Contact the office via email or phone call, and we'll get you that detailed information that you would in turn get to your broker to execute the transfer. Again, we can do this for a direct fund at the foundation, or for any any charitable entity that falls under the diocesan umbrella there. If it's Catholic Charities or your parish, we're happy to help facilitate this transfer at no extra cost. So just let us know. Thank you. The next one is the U.S. savings bonds. A number of people have these, or may have forgotten they even have these. They're sitting in lock boxes or in shoe boxes. And this is a way that people can give. You can't really even give these things away during one's lifetime without incurring a taxable event. So there's very specific wording that you will need to include in your will if you wish to give these. And then the bonds will be transferred either in electronic form or physical form to the charity, and then the charity will cash them in. So it's important that they're, again, the logistics of hand delivering them or mailing them or getting to the charity and letting the charity cash them in, not the individual. Again, and this is a taxable event if someone cashes them out or even tries to give them away during their lifetime. Do not endorse the back of them. If you need the specific wording, we have the specific wording for you to gift the U.S. savings bonds. Charitable gift annuities. These have been quite popular over the years, and we've done a number here at the foundation. Charitable gift annuity is a wonderful way to make a gift, receive income for life for you or for a spouse, and then when if it's a single gift annuity or if it's a two-life gift annuity, when the people pass away, whatever's left, the residuum, goes to benefit the charity. A couple examples, I've worked with people over the years here throughout the diocese, is that I worked with a gentleman some years back, and he had a mutual fund, and he transferred the mutual funds, did not cash them out, transferred the mutual funds into a charitable gift annuity, received a much higher rate than he was getting currently, and that is fixed for life for him and his wife. And if he were to pass away first, those payments would keep coming, every month to his wife, and vice versa. There's no paperwork to do or anything like that. Additionally, you would just let us know if one spouse passes, but the income payments are uninterrupted. You're also eligible for a charitable deduction, and if you can, in his situation, it was a large gift annuity. He couldn't use all the deduction up in 1 year, so you have up to 5 years to use that charitable deduction. It's not a not use it or lose it type of thing. You have a 5-year carry forward. So if you can't use it in year 1 or year 2 or year 3, most people have used it up by then, but you have up to 5 years to use that charitable deduction. So that was one way a gift annuity helped him. Another person I worked with was using deferred charitable gift annuity before her retirement. About 5 years before her retirement, she set one up where it would kick in on the day of her retirement. So she set up the gift annuity, but her payments wouldn't start till 5 years in the future. However, she was eligible for the charitable deduction in the year that she made the gift. So in the year that you make the gift, you're eligible for the charitable deduction, even though your income payments do not start until 2 years, 5 years, whatever year you designate for those to start. So those are just two examples how gift annuities have helped people over the years. Most people use cash or stock. Unfortunately, at this point, the way the federal law is written, you can't use IRA assets for charitable gift annuities. We're working on that in the industry, but for now you can't. But people can use cash or stock to fund charitable gift annuities. If you would like a gift illustration, we can provide them free for you. It's typically a 15-page printout of everything that you will need, from glossary of terms to your tax benefits to your income payment, everything like that in the illustration, and we can provide that to you and or to your advisors, and happy to speak with you and your advisors about that. But it's a good way to again have something permanent, because the payments are fixed, they're backed by all the assets of the charity, and it's a wonderful way to receive income for life and help the charity upon your passing. Charitable trusts, again, we could have a whole seminar just on charitable trusts. I'll just touch on a couple points here. It's a little more complicated than a gift annuity, but they certainly have their place. Charitable trusts are typically used for more complex assets, such as real estate or business interests, but can certainly be set up. You can have multiple income beneficiaries as well as multiple charitable beneficiaries. There's a number of charitable trusts that are out there. Some trusts, are annuity trusts, some are unit trusts. There's a flip trust provision when you're using real estate. So there's a lot of different options there. Charlie's going to talk about revocable living trusts. We're a little different than charitable trusts. So don't confuse the two. A charitable trust would need its own tax identification number, against and annual accounting and things like that. So it's a little more complicated, usually for larger gifts, but can certainly have its place for more of those complex assets, as I mentioned, such as real estate and or a business interests. So if you'd have any more questions about the charitable trust, they're very specific to the individual, but would be happy to speak with you about those as well. Next slide, please. Endowments, as Maureen was mentioning earlier, this is really the main fund of the foundation. We have endowments for schools, for churches, for various ministries. I believe over 150 or so, and it's a way to make a permanent gift in perpetuity. So people will fund these during their lifetime. Some people will fund these via a testamentary gift through their will. And a number of people will do both, start funding them during their lifetime to see the impact that the endowment is having, and then also leave a gift through their will for the endowment. A number of people have named their endowments, typically family endowments. And again, a wonderful way to make a lasting impact on the charities that meant the most to you during your lifetime. There are some testimonials online, as Maureen mentioned, that you can read of different people who have gone down this journey and setting up these endowments, and they're wonderful, inspiring stories. So I encourage you to read them. Next slide, please. Also, as Maureen was mentioning, the endowments are professionally managed by our professional money managers. We follow the USCCB Social Responsible Investment Guidelines. That means the funds are screened to make sure there aren't any investments there that are against our Catholic faith, such as anybody invested in nuclear weapons or pornography or anything like that. We make sure those are screened from morally acceptable companies. We have additional contributions at any time. So if you set up an endowment, you can certainly give to it annually and give to it through your will as well. You will receive quarterly fund performance reports to see how your endowment is doing. There's the option for annual grant distributions. Some people don't have any distributions until it reaches a certain amount, or maybe don't even want to start the distribution until after they're passing. But you can certainly have annual distributions as well. So you've got some room there to decide what is best for you. And then the grants are in accordance with the mission of the foundation, which is the mission of the Catholic Church. So pretty much any charity that's doing good work within the diocese, we can help set up an endowment program for, and get that working, as soon as you'd like. Before I hand things over to Charlie Davis, our attorney, just wanted to let you know, when you're setting up a will, you can make that will as Catholic as you'd like. Benjamin Franklin, who wasn't a Catholic, began his will in the name of God. Well, we can begin our will in the name of the Father and the Son and the Holy Spirit if we'd like, right? It's important to have a faith declaration, right? If your faith meant a lot to you. There's even options for forgiveness provisions, as you see there. From the depths of my heart and soul, I forgive anyone that has hurt me consciously or unconsciously, intentionally or unintentionally, throughout the course of my life's journey. And I pray that all will forgive me. These are the type of provisions that you can include in a will. There's also, we talked about the tithing already. And then Gregorian masses. This is an opportunity for 30 consecutive masses to be said after your passing. there is a wonderful organization, not associated with the foundation, but is in Pittsburgh. It's the Seraphic Mass Association, and they specialize in assigning Gregorian masses. So if you'd like more information on that and how to put that in your will, we'll be happy to get you that information. So now I'm going to turn things over to Charlie. As I mentioned, Charlie is an estate planning attorney in Raleigh at Poehler Spruill, and he's going to walk you through these documents. And I'll be back a little bit later to wrap up. Take it away, Charlie.
Thanks, Ryan. Hope everybody's doing okay today. Again, my name's Charlie Davis. I'm an attorney in Raleigh with Poehler Spruill, and I've given a number of these presentations on behalf of the diocese. I hope it's informative for you and you'll learn a little something about the estate planning process. So just sort of as an overview of this process, there are certainly legal documents we'll get to in a second, but I think it's important that you understand that the estate planning process really is that. It is a process. It is not just having documents prepared that you sign. It involves more than that, and it's important that the advisors in your life, understand what your goals are and what your plan will be, and that you get them on board with that and connected with each other, so that your plan will work the way you want it to and in an efficient way. So, for instance, your attorney that's drafting these documents and giving you legal advice about the process should be connected with your financial advisor if you have one. They should be connected with your tax preparer. They should be connected with your physician with regard to healthcare matters, that kind of stuff. If everyone is on the same page, then your plan will work much better and more efficiently than if no one's on the same page. So these are the documents here on this slide that are typically involved with an estate plan. It is, again, much broader than just these documents. For instance, if you own a bank account that is jointly held with a right of survivorship with someone, that is very common for married couples. Married couples often own checking accounts or savings accounts or investment accounts jointly. Those assets will pass according to the contract you have with the bank at your death. So if you own it jointly with a right of survivorship with someone else, the surviving owner will become the owner of that property at death, regardless of what your will or other documents say. Same thing, there are assets that have beneficiary designations associated with them, most commonly life insurance and retirement accounts like 401ks and IRAs. But you can also have pay on death designations for most any financial asset. The beneficiary that you've named for that account will become the owner of that asset at your death, regardless of what your will says. So we'll get into each of these documents in a second, but typically in an estate plan, you have a will, you have a financial durable power of attorney, you have a healthcare power of attorney, and you may have an advanced medical directive that is maybe a part of the healthcare power of attorney. It may also be a separate document. And then you may have a revocable living trust, which I'll get to in a second. So next slide. Okay, so the durable financial power of attorney, or durable power of attorney for finances, this is a document where you appoint someone to be your agent with regard to financial and property matters in the event you are unavailable to deal with that account or asset. So when you sign this document, you're appointing someone to go to the bank for you, sign checks, sign deeds, manage your financial affairs on your behalf. It is vitally important that everybody has one of these documents. If you do not have a durable power of attorney for finances and you become incapacitated because you develop Alzheimer's or have an accident or an emergency that renders you unable to manage those things for yourself, and you don't have this document, you will have to have a guardian appointed on your behalf to manage your affairs for you. And that can be time consuming and expensive. Guardians are overseen by the clerk of court. And so anything and everything that a guardian does on your behalf has to be presented to the clerk of court and accounted to the clerk of court and approved each year. So it can just get time consuming and expensive, and it's best to avoid that if you can. And generally a power of attorney will avoid having to have a guardian appointed to manage your property. So that answers the first two questions. What is it and do I need it here on this slide? There are different types of powers of attorney. One is a general versus limited. So a general financial power of attorney is very broad. It grants your agent most any power you could think of that they may need to use with regard to your finances or your property. Most powers of attorney that get drafted these days in the estate planning context are general durable powers of attorney. You can also have a limited power of attorney. And as its name states, you are granting just limited powers to your agent in that context. The most common example of a limited durable power of attorney or limited power of attorney is where you're granting someone the authority to close a real estate transaction for you. So for instance, if you're selling your home and closing gets delayed to a time when you have a trip scheduled to travel to Europe, you can sign a power of attorney that allows someone else to sign the closing documents on your behalf. These typically are limited both in powers and in duration. So, you grant this power of attorney for a 30-day period and it expires at that time. And during that 30-day period, the agent is only allowed to do this one transaction for you. So in the estate planning context, most of the powers of attorney you'll see are general powers of attorney, not limited. You may also see the word springing power of attorney. So most powers of attorney are immediately effective when you draft them, or when you sign them. So you are appointing someone as of that moment in time to manage your finances for you. That gives someone power. They are required to act in your best interests. You're appointing what's called a fiduciary. This person has a fiduciary relationship with you, which means they're legally obligated to act in your best interests and according to your direction. And if they don't do that, they could be subject to civil and criminal liability. Some used to be that what are called springing powers of attorney were more common. This is where you appoint someone to act for you, but only upon your incapacity. So while you're able to manage your affairs, no one has the power to act on your behalf. I think some clients took comfort in that, thinking that, if no one can act while they can, no one will go do something they wouldn't want. Until it becomes necessary to have someone act for you. These are less and less common though, because it can be difficult to get a declaration that you're incapacitated. Usually that comes from a doctor. You have to get in front of the doctor. They have to be willing to make a written statement to that effect. And then typically that written statement is going to have to get filed on record so that anyone that sees it can rely upon it. So usually we do not do springing powers of attorney. We just advise clients to appoint someone that they trust will do a good job and will do things in their best interests. Usually when clients sign these durable powers of attorney, they keep them in their own home, in the file cabinet, or wherever they keep their important documents. And so their agent doesn't have the document at that time to even start using it. But if they do need to start using it, they can go get it and find it. So another word here, durable, that you see for powers of attorney, that just means that the power of attorney will last through your incapacity. So if a power of attorney is not durable, the effectiveness ends when you become unable to act on your own behalf anymore, which sort of does away with the reason why you probably signed a power of attorney. So almost every power of attorney you will ever see will be a durable power of attorney, because we want it to be able to be effective when you're unable to manage your affairs. Next slide, please. Okay, so well, and one more thought I forgot to mention for the last slide. You can stay on this slide, but for the durable power of attorney, one important thing to remember is use the power of attorney as a way to have your affairs managed for you. Don't just go put someone else on your account. We usually don't advise clients to have a joint owner or put someone else on their account that is not their spouse. Usually if you go to the bank and you say, I'd like to put my child on my account so they can help me with my bills, what the bank is going to do is they're going to make that account a joint with right of survivorship account so that your child becomes an owner. And there's a couple issues with that. So first, it's a joint with right of survivorship account, which means that that child will be the owner of your account at your death. That may unintentionally disinherit your other children, if you have them, or your other beneficiaries. The other problem with that is it could expose that account to your child's creditors. So if your child gets sued for some reason, they get in a car accident, or they're a professional and they get sued for professional malpractice, like a physician or a lawyer, then potentially that account could be exposed to their creditors. So, just don't do that. Use your power of attorney as a way to allow your child to do those things for you without actually making them a joint owner. Okay, next slide to the healthcare power of attorneys. Okay, so this is similar to the financial power of attorney, except that it deals with healthcare decisions. So you're appointing someone to make healthcare decisions on your behalf. This document is only effective when you're unable to make your own decisions. So as long as you can state your own wishes with regard to your healthcare agent that you've appointed will not have the ability to make a decision. But it's a good idea to have this document because you get to appoint the order of people to serve. So usually, folks appoint their spouse and then their children together, or some order for their children, depending on their wishes and their, children's background. Sometimes someone has a child in the healthcare industry, and so they think they may have a better idea as to, what these decisions would mean. If you have one of these, it's important to appoint someone who would actually make a decision. Sometimes if you appoint someone who's a little bit wishy-washy, they may not be able to make decisions at a very difficult time in your life. So you want to appoint someone who would make decisions in accordance to your healthcare power of attorney and your discussions with them about what your wishes may be. So an advanced medical directive, sometimes it's interchangeably called a living will, although there are some differences, particularly with the estate planning packet or booklet that Ryan mentioned earlier. So there is a living will or just a general advanced medical directive is a document that states your wishes with regard to end-of-life treatment. So there is a form that North Carolina puts out that you could use, and a lot of our clients use it, that is based on what the legislature has put out on their form as to what decisions you would want made at the very end of life. The booklet that Ryan mentioned earlier has that's a very similar document, but it is guided by the Catholic faith. And so it has more specific directions or options on that document that align with the Catholic faith, which of course the North Carolina statutory form doesn't include. And so it'd be a good idea to review that booklet that Ryan has mentioned. But this document also in that booklet deals with end-of-life decisions and helps guide your loved ones if they're ever in that situation of having to deal with your healthcare at the very end of life. So it's a good idea to have this document so your wishes are noted. All right, next slide. Okay, so the main document for estate planning that most people think of is a will. everybody needs one. This document appoints your personal representative after your death. That's usually known as your executor. So your executor steps into your shoes at death and can continue to manage your affairs at that time. Power of attorney that you've signed during lifetime loses its effectiveness at your death. So your executor would step in at that time. So this would be to collect any payments that are due to you, to pay, your creditor claims. If you are involved in litigation at that time, your executor could step into your shoes then. But really, it's collecting your assets and distributing them in accordance with your wishes. So everybody certainly needs one of these. When you do pass away, your will gets filed at the courthouse, and your executor is appointed by the clerk of court. Then your executor will collect your assets, report those to the clerk of court. They will report any creditor claims they receive. They will pay those. They will file an accounting with the clerk saying, here's what was in the estate, here's how we use the money, here's how we distribute it to the beneficiaries. And so that's called the probate process. It is not inherently a bad process, but it is a good idea to avoid it if you can on certain assets. And when we get to the discussion on revocable trusts, I will get into that in more detail. But that process can be time consuming. The probate process can be time consuming. It can be expensive, and it can just be a little tedious and drawn out. So to the extent you can avoid it, it is a good idea. Should you just write a will for yourself? This is self-serving, right? I'm an attorney, but I don't think that's a good idea. You don't know what you don't know. I don't diagnose myself with medical conditions. I go to my primary care physician to do that. And the same applies here, right? You should go to a professional who knows what they're doing and can help give you good guidance and advice on the process and how to meet your goals the best way possible. So it's best to have an attorney help you with this process and not just do it yourself. So if you have a will, the benefit of it is what you want to have happen should happen, particularly if you have had an attorney help review your entire estate plan and beneficiary designations, joint accounts, all that. If you have an attorney help you with that and they've drafted a valid will for you, then what you want to have happen should happen. If you don't have a will, North Carolina and every other state, if you live in another state at your death, has a statute that governs who gets your property. It is not always what most people would assume would happen. So for instance, if you're married with children, most married couples in that situation would want everything that they have to go to or for the benefit of their surviving spouse if living. And if not, they would want their property divided up amongst their children. There are certainly exceptions to this. People have different goals and desires, but that's sort of the most common scenario. If you die without a will, though, and you are in that situation where you're married with children, your surviving spouse will only receive a portion of your estate. Depends on how long you've been married to them. But if you've been married for at least 15 years, your surviving spouse will be entitled to 50% of your estate, and your children would be entitled to the rest. There's a public policy behind this. Not all married couples or not all children of married couples are children of both spouses. And so making sure children are taken care of is a good thing, right? But in most scenarios, at least for most of my clients, they're married and their children are children of both of them. And so they would trust that their surviving spouse would take care of their children if everything was left to the surviving spouse. Also, if you have minor children and they inherit something from you outright, you'd have to have a guardian appointed for them, and the same process I discussed earlier would have to happen. That guardian would have to report to the clerk of court every year for what they did on behalf of that child. And so it's best to have other structures like a trust for a minor child so that you can avoid that public guardianship process. If you are married and you don't have children, but your parents are still living, and you die without a will, then your spouse will have to share her or his inheritance with your parents. And so that could be an awkward situation. Hopefully your parents will be very generous and allow the spouse to, gift whatever they receive to your spouse, but there are tax implications with that as well. And so it's best to just have a will so you can make sure what you want to have happen will actually happen. Okay, next slide. Okay, so I discussed the probate process earlier, and I mentioned that it'd be a good idea to avoid it to the extent you can. And one way to do that is with a revocable living trust. Sometimes we just call them revocable trusts, or sometimes just living trusts. So these are documents that you set up. You appoint a trustee, usually yourself, to manage property on behalf of the beneficiaries. And while you of the trust, and while you are alive, you are the trustee and the beneficiary. So it is property being held in trust for your benefit. You can change these things at any time. You can amend them, revoke them. They really are you by another name. There is no separate tax filing for setting this thing up. So it doesn't file a tax return. The IRS doesn't care that it exists. But the benefit is anything that is in the trust at your death avoids probate. So it doesn't have to, you don't technically own it at your death, your trust does. And so you do not have to report that asset to the probate court or pay fees on it at the probate court or account to the clerk of court for that asset. So it avoids fees. It can cut down on some administration time. It can help avoid legal fees, and it maintains privacy. So your trust typically does not get filed at the clerk's office. And so no one can see who your beneficiaries are or what you had in the trust at your death. So it can be a really good tool for people who just want to make things a little easier for their beneficiaries at death, or who want to maintain privacy. Trusts offer revocable living trusts like this also are great beneficiaries for life insurance and retirement accounts. You can name them as the outright beneficiary of life insurance. For retirement accounts, they can be a beneficiary as well. Usually we use some customized language to do that, but they can be great beneficiaries for those as well. And if you name your trust as your beneficiary, you can then change the trust later, and you don't necessarily have to update your beneficiary designation. An important thing to remember with probate avoidance is you don't have to have a trust to necessarily do that. I mentioned joint accounts earlier and accounts that are payable on death to someone with a beneficiary designation. Those assets avoid probate because of the right of survivorship or the pay on death beneficiary designation at your death anyways. And so you don't need a trust for those assets to avoid probate. But if you have an investment account that you just own individually, that would be a great asset to consider putting into your trust before you die. Another asset to consider would be real estate that you own in a state other than the state where you live. So if you have a vacation home in another state, it's a great idea to consider putting that into a trust before your death. Otherwise, you'll have to have a probate proceeding in another state, which you would want to avoid. Before you do that, you want to review any governing documents for that real estate, like a mortgage or deed of trust, to make sure you would not be violating any transfer restrictions on that. And if you do have a mortgage that says if you transfer the property, we'll call the loan, you can usually get consent of your lender if you're going to transfer it to your trust. Because again, this revocable trust is just you by another name. You're not trying to give it away to somebody else. You're just using it to avoid probate and maintain privacy. Okay, next slide. So I've alluded to this a few times already. The estate planning is a process. It's not just documents. So you know, in this process, you would want to review how you own your assets. and what beneficiary designations are associated with any of those assets, so that you can make sure all of your assets will pass as efficiently as they can to the beneficiaries that you want. So for instance, if when I started my first job, I was not married, didn't know my wife at the time. I had some life insurance through work, and I named my sister as my life insurance beneficiary. I'm now married, and I have thankfully updated my life insurance beneficiary designation. But if I hadn't done that and I pass away, my sister's would have received life insurance money, not my wife, which is of course not what I would have wanted. And so it is just a great idea in this process to review everything you have and make sure those beneficiary designations and your account ownership is, how those will work, in addition to knowing what your will says and your trust says. Okay, next slide, please. So, we like to tell clients that they should probably review their plan every 4 to 5 years, just as a baseline. Your family situation could have changed in that time frame, or your health could have changed, or the law could have changed that might make it beneficial to revise your plan. So, if you don't have a terminal prognosis or anything like that, every 4 to 5 years is a good time to review your plan. If you do have a terminal prognosis or something happens in your family that directly would affect your plan, it's a good idea at that time to go ahead and have a review and make sure your plan is gonna work the way you want it to. So that's about it for my part of the presentation. I'm happy to answer any questions that people have via email. I think Alicia can send my contact information around if you guys don't already have it. But yeah, hope you learned something today, and I'll hand it back to Ryan to finish out the presentation.
Thanks very much, Charlie. Wonderful information. Great job there, and I encourage anybody with any technical questions there on those documents to reach out to Charlie directly. If you're looking for ideas for planning, most people will meet with myself first, at the foundation to just go through different examples, option 1, option 2, things like that, and then go see an attorney to finalize everything. Again, it could be costly there if you don't have an idea and you're just constantly meeting with an attorney. It's better you put together a plan, and that's what we're happy to help with, and then go see an attorney to finalize everything. The last few slides here are just the foundation funds and events. This, if you have already named, next slide, please. If you have already named the any diocesan entity, your parish, a fund, Catholic Charities, any entity within your will or estate plan in any way, you're eligible to become a member of the Father Price Society. Father Price was the first Catholic priest in the Diocese of Raleigh, and his cause for canonization was opened by Bishop Burbidge back in 2012. And each year we have a luncheon to honor those members who have already named, again, any diocesan entity in their plans. The luncheon is this month. It's in Raleigh with the bishop. We have a mass first at 11:30 and the luncheon to follow. It's on the 25th of October at 11 o'clock. So if you have, again, named the any entity within the diocese in your plans, please reach out to the foundation, let us know, and we'll get you, and you want to attend the luncheon, we'll get you registered for the luncheon. And it's also a way for the bishop who will be there, Bishop Zarama, to say thank you. And then what Maureen said, we have a few funds that are currently available here at the foundation that can really make an impact on some of the poorer areas of our vast diocese in the east and the southern part. And one of them is the Home Mission Fund. It's an annual fund that provides grants to rural parishes. There's been a number of parishes built. There's one right there in the background. Grants up to $400,000 are awarded to parishes on the initial investment of building. Parishes already established have land doesn't have capital to build or expand a church, they get funding too. So it's a wonderful way to have an impact today as well as in the future for the Home Mission Fund. Next slide, please. And the final slide here is our Seminarian Partnership Program. Seminarians are supported through the BAA, but this program is, but so is 30 other entities. So when you make a gift there, it's not restricted just to help the seminarians. So if you would like to make a restricted gift just to help the funding of our seminarians, the Seminarian Partnership Program was established some years ago, and it helps with their needs of tuition, room, board, and travel insurance, things like that. So let us know if you have any questions there. Again, a wonderful way to make an impact today through an outright gift, and also set up a gift for future years to make sure that the vocations are perpetually funded. Any questions? As we've mentioned, please reach out to us directly at the foundation. Happy to answer them. Happy to set up follow-up meetings with you or with your advisors. The offices are located not too far from 440 down there in Raleigh. So please let us know. We'll be happy to meet you at the foundation to talk things out some more, or wherever location or parish is convenient for you. Also, again, happy to have a conversation over the phone as well. That wraps up our presentation for today. So on behalf of Maureen Lindgren, Alicia Hastings, Charlie Davis, and myself, Ryan Flood, thank you for attending. Have a wonderful day, and may God continually bless you. Take care, and God bless.
Thank you, Ryan. Thank you, Charlie. Thanks, everyone. I will be sending out an email for those of you that are still on here regarding the booklets, etc. Have a great day.